Good evening, everybody. I hope you are all doing well. And this is Jonathan Ginsberg. Welcome to my live stream, my weekly live stream. If you are seeing this on replay, we are here every week, just about every week. Every once in a while I miss one, but usually around 8:30, 8:45, depending on the season. I will be here live for a couple of hours answering questions about Social Security disability. I have guests sometimes. Last week I had my colleague Stephanie Joy. I've got some additional attorneys coming up. I've got a Social Security adjudicator coming up. I've got some interesting folks. So please, if you have not already subscribed, please do so. And hopefully we'll see you here every week. And you can post your questions. I will do my best to answer those. And we can have discussions about all things Social Security disability, what it takes to win a case, what it takes to preserve your benefits, and some of the strange letters and so forth that you're getting from Social Security. So with no further ado, let's kind of jump into the questions here. We have one from Michael Jennings. Is telling me that his state has a program for those who meet Social Security's definition of disability, but cannot consider SGA or substantial gainful activity. Maybe that that you are disabled, but you're not able to work at SGA level. Excuse me. Wow. If I go back to work successfully, can I somehow get a continuing disability review? And you want to continue to get Medicaid and so forth. So I've not decided to go back, but I'm trying to figure out if it helps or hurts financially if I choose to do so. I think, and again, I don't know about these different state programs. Realize that Social Security, when it looks at work after you've been approved, I don't think that other programs, state programs, are going to have anything to do with it. In other words, they're going to make their own determination as to whether or not you have regained the capacity for work. So if you go back to work and you're working ongoing, even at a part-time basis, that could trigger a continuing disability review. Now, in theory, if your earnings are below SGA, which in 2025, $1,620, then you would not be, working. You would be considered to be under SGA, and it shouldn't affect your disability. I will tell you, though, that my experience has been if you are working part-time ongoing and you're close to SGA, let's say you're $1,500 per month, something to that effect, you could trigger a continuing review because they're going to look at it and say, well, you're working, not quite at SGA level, but you're really close to it month after month. What's to say that, you're not intentionally suppressing your income, or that if you worked a little bit harder, you could be over SGA, which, by the way, is about $19,000 a year. We're not talking about a lot of money. So my point here is, Michael, I don't think that going under your state's program, to my knowledge, would insulate you from Social Security doing a review. I could be wrong about that, and there could be some arrangement between your state and Social Security that says if you're part of this program, it's a structured work setting, it's not going to count. But I just think that anytime Social Security sees earnings, that is potentially a risk. Sometimes it makes sense. If you're 58 years old and you're working and you're earning $1,200 a month, I don't think the risk is that great. If you're 35 years old and you're making $1,400 or $1,500 a month, the risk is greater. So I would not think that a state program is going to insulate you from a review if you're showing you have some capacity to work, perhaps close to the SGA level. Okay. Essay, if someone has exhausted all therapies with orthopedics, does not want surgery for lumbar radiculopathy, what do they go to the pain clinic for? Primary care can prescribe gabapentin, which is a nerve pain medication. All conservative methods have been exhausted. And what Essay is getting at is, I've said on this live stream before and on my videos that an absence of medical care says to Social Security that there's an absence of symptoms. So you've got to go to the doctor. I also have said many times that going to a specialist, an orthopedic, a pain management doctor, is better than going to your family doctor, because these are, pain management, orthopedics, neurosurgeons, neurologists, they're specialists in this. And so what SA is saying is, what's the point of paying for a specialist if they're not going to do anything for me? And I hear you, absolutely hear you on that. The problem is that, in my experience at least, family doctors are discounted a little bit. So if, I think as long as you're getting prescription, you've exhausted all the conservative treatment, there's a record of that, your MRIs, which is really important, show an ongoing problem, in your lumbar spine, you're not a surgical candidate, or you decided not to go through surgery, then you go to your family doctor for prescriptions. In theory, that shouldn't be a problem. Would Social Security look at it and say, well, you're just going to the family doctor? Maybe. Um, if it got to a hearing, I think I could make a pretty compelling argument to the judge that the reason you're not going to the specialist is because it's expensive. They can't do anything for you. The only thing they're doing is the same thing your family doctor would be doing, but you don't want to have to go to a hearing on it. So again, this is just because you got to play the game. My feeling is, even if you go once a year, once every 18 months, go to the pain management doctor, go to the orthopedist, and at least confirm what you're doing with your family doctor. I think that's probably giving you some level of protection. I keep coming back to, I don't feel really comfortable telling somebody that going to the family doctor alone is enough, because I've just seen too many unfavorable decisions where the judges, referencing the fact that the person did not see a specialist, the family doctor. I think that they sense that family doctors sometimes, because of longstanding relationships, might, say that you are more disabled than you are because, they have a personal relationship with you. Whether that's true or not, I don't necessarily think so. But, if you're asking me, is it better to have a prescription from a pain management doctor, an orthopedist, as opposed to a family doctor? I do think it's better. If it doesn't make sense economically, you can't afford it, spending the money, there's no reason for it, I think, that would be an explanation as to why you did it. But I still say once a year, once every 18 months, maybe even every 2 years, go to the specialist just to confirm nothing has changed. I think you want to have MRIs every 2-3 years. If you haven't had an MRI in 5 or 6 years, Social Security is going to look at it and say, well, that MRI that you had 6 years ago is stale. So, you have to be proactive when it comes to your medical treatment. You've got to be your own advocate. But I just don't know that family doctor alone is always the best idea. That's my opinion. Others may disagree. That's my opinion. This is Karen, one of my clients, Autumn Harvest Dude Ranch. Doodles are not a dude ranch like, cowboys and Indians, whatever, but this is a Doodles. I think it's Labradoodles, if I'm not mistaken, Karen. I don't know. Anyway, if you decide to get married where in the process of SSDA will have an impact on your case, not at all. This is based on your earnings record, not on your household income. Would your future husband's income come into play? No, it would not for an SSDI case. It would for SSI. Would your case have less weight because you have somebody helping me? No, I think that, again, if anything, you have a spouse helping you with daily activities. I think that just shows that you have less capacity. I don't know that getting married is going to, if anything, it just shows you need more help. So I don't think that's an issue at all. So if you get married, congratulations, first of all, but I don't think that has any bearing whatsoever. Obviously, if you go on a honeymoon for 3 weeks in Tahiti, that's problematic. If your husband likes to travel and you're going long distances, that could be an issue. But if anything, it just shows you've got more help now because you've got someone who is there all the time that can help you with physical tasks and with, keeping schedules and things like that. So no, I don't think it affects it at all. Anything, it's neutral. It can help you. And yet now you have another person who can observe what you're going through. SSI, because it's means tested, it would, but not on SSDI. And you're very welcome. Happy to give my time. This is what I like to do. SA is the person who's asking about the family doctor. Yeah, gabapentin, people, they call it GABA brain. Neurontin or gabapentin is a nerve pain medication, terrible side effects. Not unusual for people to say the side effects are as bad as the underlying pain because it makes you totally loopy. And I've had many cases where I argue that the side effects of gabapentin are so significant that it would make it really impossible for somebody to work. Christina, president of my fan club in California. Hello, Christina. Hope you are doing well. Bama DRB, good evening. My question is SGA more for legal blindness, but is it a trap? Okay, what is, Bama D is saying is that SGA, it's a higher figure for legal blindness. I don't know what you mean by a trap. I mean, you can earn more. What it basically says is that and let me see what SGA for blind people is, and blind is a very specific diagnosis. SGA for blind 2025. So it's 1620 for not being blind. For blind, well, let's see if I can find it here. Let's see what we got here. For 1620 for people who are legally blind, Social Security defines it $2,700. So basically, you can earn more money as a person who is blind without hitting SGA. Not really sure why that they have that distinction, but they do. So you can earn more. I guess they feel like if you're able, even if you're earning more, the number of jobs you could do if you're legally blind is less. So even if you found one that you can earn money at, that does not mean that you have a lot of capacity to go do other things. And generally for Social Security purposes, you want to look at the listing, the special senses and speech listing. I'm not sure which one that is. Let's take a look. I think it is listing number 2, and it talks about loss of visual acuity and contraction of the visual fields, things like that, 2.02, 2.03, 2.04. So I think you have to be pretty close to the listing to be able to say, I am blind for Social Security purposes, and therefore I can earn more money and still be under SGA. So don't just assume because your doctor has told you you're, quote, legally blind, that you now have the higher dollar figure. You've got to be blind as the way Social Security sees it at 2.02, 2.03, 2.04. Go to meetalisting.com if you want to link to the listings. But I don't think it's a trap. I just think it's a recognition that people who are legally blind, even if they find a job, there are probably a very limited number of jobs that somebody could do with very poor visual acuity. So they feel like even if you could make some money doing it, there's probably only a few jobs that you could do. All right, Karen has one more question. If a family member decides to give me money to help with expenses during the process, does that help hurt your case? No. Again, gifts, inheritance, household income does not impact an SSDI case. It does impact SSI, but not SSDI. So if somebody's willing to do that, then go for it. Oh, pardon me. My Blue Moon, 1969. For 10 months in Recon, received a letter from the examiner to complete my doctor's information support docs. At 57, what should I expect to be happening next? Is this common? Well, what is unfortunately more and more common is that cases are, that you file your appeal to Recon, and it goes back to the Social Security adjudication office. But in many states, it may sit there for 7, 8, 9, 10 months before it's actually assigned to an adjudicator. So being in the office is not the same as being assigned to an adjudicator. So, because they're so overwhelmed with cases, a lot of cases they call it being in staging, where they sit there and nothing happens because nothing's being done for, months. This is where, by the way, a congressional inquiry can get things moving. But, it's been 10 months at Recon. If, that's a way too long, they're now asking for information. It looks like they're just starting to work on it. So you're probably 5 or 6 months away from a decision. As far as what to be happening next, they're going to gather medical information. If you have anything new, you can submit it. It will go, then once that's gathered, that could take 3-4 months to gather. They will then send it to a medical expert. This is a doctor who moonlights doing this. A lot of times they're pediatricians, they're family doctors are making a little extra money. A lot of times they work at night. I talked to an adjudicator, senior adjudicator last week, who I hope I'm going to have on here soon. And this person basically said that a lot of these doctors, they're working, they can see when they come on, and they come on the computer system at 2 a.m. because they're just doing this to make a little bit extra money. So, don't be surprised if the adjudicator doesn't get to it, isn't even assigned for 5, 6, 8, 10 months. So what's going to happen next is the records get gathered. They then send it to a medical specialist, somebody to look at it. The medical specialist, drafts up a written, description of what that person's seeing and opinions, and it goes back to the adjudicator who makes the final decision. And one of the things I do when I do my brief is I will many times look at what the state agency adjudicator found, their medical doctor, and rebut it, and basically say they didn't consider the effect of pain medication. They didn't consider the effect of pain. But I will use, if they found what the person's past work was, or they're limited to sedentary work, or they have no transferable skills, I can use that in my favor. I will use it in my favor. So that's what's kind of going on behind the scenes. And again, I think we'll have an adjudicator on next few weeks to tell us a little bit more about that process. Karen asked, is there a way to get old medical records from 10 to 15 to 20 years ago if the surgeon has retired? Hard to do because a lot of these records end up in storage. You can reach out to the doctor and see if those records were transferred to another practice. Maybe he joined before he retired. Are they in storage someplace? The reality, though, is, if you were working, this is relevant for historical purposes, but if you were working, up until 2 years ago, what happened 15 years ago, you can really testify about. I don't think you need records. And I don't know how much it's going to really make a difference. If you had surgery and you had some real problems 15 years ago, 10 years ago, but, you are now, but you were able to go back to work for 8, 9, 10 years, and now you're out of work again. What happened 15 years ago? I just don't know how it's really all that relevant. And it's not going to be something you want your case to be held up for. But I think you can certainly talk about what happened. It may be referenced in the record by history. And again, this is something you've told your doctors. I had a laminectomy 15 years ago. You can talk about it. But, reality is, unless, something's really odd, you were able to work through that up until the last couple of years. JC Sports, this is replying to SA, and SA is, again, the person who does not want to have additional surgery, but is concerned about going to a pain specialist or orthopedic when there's really nothing they can do. And also noted that gabapentin makes you really feel fuzzy and doesn't always help. And JC Sports is basically saying that he's had the same experience with gabapentin. And, it's different for everybody. Some people find that gabapentin takes the edge off. Other people say it makes them feel like a total zombie. It just depends on your makeup. Eunice is one of my regulars here. Thank you very much. You're welcome. Good to see you. Dimple Bellamy, good evening from Ohio. Dimple, good to see you here. Christina reminds everybody to press the like button and subscribe very much. Thank you very much, Eunice. I appreciate the kind words. Happy to do it. Good to see you here. Chrissy's Coven. Do I need to provide letters from my doctors with my application for my severe complex pain conditions, serious mental illness? I lost the case last year, needed multiple surgeries, ketamine infusions, 36, haven't been able to work since 2012. All right, so Chris, you bring a couple of issues to the fore. One is you haven't worked since 2012. You are, assuming you work pretty consistently until then, your insurance coverage likely ran out in 2016, 2017. So right now, 2025, you're almost certainly not insured for Title II disability, which means your case is SSI only, which has all the income and resource limitations there. So that's one thing. So just be aware that you're probably looking at SSI only. As far as, you had a case, you lost your case, I'm guessing, at a hearing, and you're reapplying. I think if you've got letters from your doctors, definitely submit them. If you lost at a hearing, generally speaking, a judge is not going to go back and reopen what was already decided. So if let's say you had your hearing, you got the decision in, April 15th of 2024, the earliest onset you could have for a new case would be April 16th of 2025, right? Day after the unfavorable decision. If it's a initial recon, this doesn't apply. But if you went to a hearing, that's where you'd be. So, things that medical records that preceded that, could be relevant, but they're not going to, find you disabled back, 10 years ago if that's already been decided. So, it could be, anything that helps get it submitted. But as far as, reopening or going back in time for your disability benefits, that can be a challenge if you've already been denied. Another thing Chrissy notes is she's 36. That is young. 36 is young. So I tell you is it's a lot harder to win at 36 than 56. And that's part also why you've been denied. It's just, they just make it a lot more difficult. Okay. What do you say to the pain clinic when you said, if you said everything, if nothing was left, you don't have to get any kind of invasive procedure. I think it would be helpful if the pain clinic doctor noted in the record that you've tried multiple pain medications. Nothing seems to be able of controlling your pain. You've been released back to a PRN, which means as needed status, and you are continuing treatment with your family doctor. I think if you document that and make it clear that there's really nothing more they can do for you, and they either release you or they release you back to your family doctor, then that may be all you can really do. Would I take a Spanish only case? Good. We've actually been that's a very interesting question because I've been toying with that. I have 2 fluent Spanish speaking employees, Paola, who's my receptionist, and Madeline, who is a case intake person. So, if you want to call the office, reach out, either Paola or Madeline will talk to you that Spanish is their first language. What I would need to do, because I'm not fluent in Spanish, is I would, find somebody that would be able to do the hearing for me. I would do all the prep work and then have somebody do the hearing for me. But yeah, I'm happy to evaluate it and at least give you an opinion as to what I think. Because again, I've got 2 fluent Spanish speakers. Used to have 3, but now I've got 2. So we are, in fact, I've been even talking with some other attorneys about, that speak Spanish about doing some kind of a joint venture. Hasn't happened yet, but, we get calls for that. So that may be coming down the pike. But yeah, reach out to us and we'll be happy to at least give you a case evaluation. Nickerson, okay. I'm glad that you found us helpful, and I wish you the best with your hearing. And I appreciate the $10. Thank you very much. Very, very nice. And I do wish you the best. Karina Hicks. Good evening, Karina. I hope you are doing well. I'm scheduled for surgery for TMJD because of bilaterally dislocated TMJ discs and severely degenerated. I don't even mean condolences. I did research and read another surgeon on the surgery. Causes irreversible scarring at the joints. Can I change my surgery decision because of this? You can always change your surgery decision. I think anytime you are considering going under the knife for any reason at all, you can change your mind. And Social Security will not penalize you for deciding not to undergo an invasive surgery, because every surgery, even minor ones, even like a spinal cord stem, there are risks involved. You could throw a blood clot. There could be a bad reaction to the anesthetic. Any number of things could happen. So, obviously I talk a lot about this. Documentation is really important. And, you want doctors to document what's going through. But if you make a decision not to, and the doctors are saying, the only thing we can offer you is surgery, and you make a decision, I'm not going to undergo surgery because of concern about side effects, concern about bad reactions to medications, whatever, that will not hurt you. But you do need to have the doctors talk about your capacity as it stands without the surgery. But yeah, being concerned about, irreversible, condition is certainly a reason not to undergo it. Okay. Bama, DRB, the ophthalmologist gave me a field of view test and said you meet listing 2.02. Been dealing with Jen in my office and she has your intake form. Okay. So, so obviously, that, you're at listing level. What we like to do, and I like to do when I've got somebody at listing level, is make an argument. I just did one on another case the other day to the adjudicator, and make an argument as to why the case should be approved early because it's listing level. And that would be, the way to approach that. And obviously at the higher SGA level, that gives you a little more leeway as far as working. Wizard Owlin Celestial, CDR still pending, nervous wreck. Yeah, and this is an issue. In fact, when I talked to the adjudicator, this person's, what basically said was that the cases that are being moved for termination, they're able to proceed with. The other ones, they're kind of in limbo until the end of the fiscal year, which is September 30th. And the new fiscal year starts in October. So a lot of CDRs are in limbo. I suspect after the 1st of October, they'll get them out. A lot of them will be, we're continuing benefits. But yeah, it's very frustrating when you don't know what's going on and you're in limbo. But I think part of that is because of the budgeting, and the Security does not give enough money for the people that make these decisions to process them out, other than to move to terminate. So you could argue it's good news they've not moved to terminate, but it would be better to at least have something from them. It's really doing joint condyles. Oh, condyles. Okay, so I knew there was something to that effect. But yeah, if you've got significant problems and your doctor is basically saying you're a surgical candidate, but you decide not to go to surgery, that is perfectly reasonable. AT&T has a language translation service that corporations use. Yeah, I'm not sure this is in response to the person who wants the Spanish. There's actually a very interesting AI tool. I was looking at it the other day, that, you basically put it in your ear and, somebody talks and it automatically translates. We're probably not to the point I would trust it at a hearing, but we're probably getting there, and, I know, like you watch science fiction, Star Trek and all that, Star Wars, and they have these translation devices. It would be pretty cool. I know that on the phones now, I know Apple advertises as you can hold up your phone and somebody will, like to a street sign, it'll translate it, or somebody can say something, it'll automatically translate. But, when you're doing it in a legal proceeding, you got to just be really careful because there's a lot of nuance. I mean, like I'll tell you, when I write a brief, and realize my background is, my dad was a journalist. I kind of come from a writing background, and every word, when I write a brief or I write anything, I consider really every word. I mean, just the phrasing, choosing this word over that word, it can make a difference. A collision is different than a crash, right? So, depending on what you want to say, I would be more comfortable if I was in somebody's shoes and having a hearing. I'd want a native speaker. Theoretically, or almost not theoretically, the judge will be doing your hearing in Spanish. Everybody else, the vocational witness, will be speaking Spanish. Do you really want your attorney relying on a translation program? Probably not. Now, maybe we'll get there in 3 or 4 or 5 years or whatever, but we're not there at this point. So I would still say that, if somebody came to me, and I've had a couple of cases where Spanish was my client's first language, and I gave them the option. I said, look, if we can do it in English, and I'm happy to do it in English, and, I think we have a good case and I can make the argument, and they can have a translator there for you if you want. But, if you want me to get you a Spanish speaking lawyer, and everything is done in Spanish, that may be faster, but that's just a judgment call that people make. And like I said, what I've done is I've done some with the translator, not just Spanish, but other languages. And the second thing would be, I've also referred cases out to colleagues who do speak Spanish, to do the hearing. So, it's just something that we would talk about. That is Jen from my office. I know her kids have after-school programs, so she's not been tuning in as much as normal, but hello, Jen. Hope you're doing well. Oscar, how are you doing, Oscar? We have a hearing. We do have a hearing tomorrow. And if we were going by case, I like the attitude. How long does it take to get some funds? Yeah, we have a good case. Oscar's got a good case, wrote I think a pretty good brief. We talked about it the other day. And normally what happens is, and nobody can guarantee anything. I think we have a good case, good judge and all that. What'll happen is after the case is heard, it'll go back. The judge has to issue a written decision. That may take anywhere from 2 to 6 weeks. It just depends on the workload. I get some as quickly as a week. I haven't come that quickly, but we can't control that. So it'll be 2 to 6 weeks. Once the decision comes down, they have to do what they call a non-disability review or non-medical review, is a better way to put it, where they want to make sure you've not been working. The money sometimes will drop. I've seen money drop within a month of a hearing, but more likely than not, it's a couple of months, 2-3 months. No consolation to you if you're anybody struggling financially, but this is the system we got. So we just got to deal with it as best we can. But hopefully we will have things will go the way I think they will tomorrow, and we'll be on the road. We're in the home stretch at this point, Oscar. It has a specific name. All right, St. Louis, you have got me stumped. What has a specific name? Don't know. Kenneth Thompson, 61, PTSD with weekly sessions, psychiatrist with a good letter. OS, sleep apnea, migraines. And to include massage therapy, acupuncture, your thoughts, hearings in October. I think that anybody at 61, you have a huge advantage, because if there are some physical issues, and again, these all seem not so much physical, but still being 61, there's a built-in bias in your favor. You've got a form from a medical source statement, or MSS is what they call it. It's another abbreviation, basically from your psychiatrist saying you can't work. That helps. You're 61. That helps. You've got significant symptoms. That helps. Sleep apnea tells me you don't get restorative sleep, which means that any skills you might have had from previous work, I would argue, have been eroded because you can't focus and concentrate because of poor sleep. You've got severe pain. You've got migraines. Then you have the migraines with basically a weekly massage therapy and acupuncture, which is not an acceptable medical source, but you are getting treatment. Again, I think it's 61. Anybody 61, I think you've got a good argument, just because they realize that it's very difficult for a 61-year-old with medical problems to find work. On the other hand, migraine headaches are not something you can really image. It's really based on what you report. The psychiatric issues, same thing. It's based on what you report. Although most psychiatrists have processes in their office to ferret out people who are malingering or exaggerating. So, that probably is not going to be an issue. So I think all is said and done, you're probably in pretty good shape. But it's always a bit of a challenge when you have non-exertional impairments like, basically, PTSD, sleep apnea, migraines. These are all things that, a doctor's relying on you. Now, sleep apnea, they can do tests to see, but sleep apnea, I've never won a case solely on sleep apnea. It adds to problems, but it's rare that you have somebody whose poor sleep is such that it would prevent them from doing anything during the day. So I think all in all, it's pretty good, but sleep apnea is probably your weakest argument there. Okay. Played tennis and did not do very well today, unfortunately. Okay, Christina says, please leave a 5-star review. Thank you very much. Thank you, Christina. It's by the way, and I appreciate the comment. It's BERG, not BURG. So if somebody's looking me up, it's BERG, not BURG. But yes, thank you very much, Christina. Leave me a comment. That really helps us grow true. All right, Tom says, I think Tom's been here before. I'll be 60 in November. Will grid rules apply for 60 and over? Yes. Firm applied for hearing in mid-June. Am I getting closer? It normally when you apply in June, it's a 5, 6 to 7 month process to get a hearing. So if you applied in June, we're already 2.5 months in. So we should get a hearing probably in the next, at least a hearing date in the next, 30 days, 20 to 30 days, something like that. It just depends on how busy the hearing office is. But it really helps that you're 60 because, again, the grid rules can apply if you've got physical limitations. And at 60, if you have skills, there is something called the PALMS regulation where it talks about transferability of skills. And it basically says if you're limited to sedentary or light, that Social Security recognizes that any skills you might have had will be very difficult to translate. They're not going to expect a 60-year-old to learn a completely new industry, is what I'm saying. They might expect a 35-year-old to do it, but not a 65-year-old or 60-year-old. So I think that all helps. But we'll just have to wait until they give a hearing. Okay, I think we talked about acupuncture and occupational physical therapy, which is acceptable. Acupuncture is not. Although, again, they recognize you're going. It's just that they're not going to take the conclusions of an acupuncturist or a clinic director or somebody who's not a licensed psychologist. They're not going to give it any weight, but they will see you've gone. So that can help a little bit. Christy, years before going in SSI, did my try to work and earn 4 credits. Asked my credits union to transfer 24 total. Well, I can't speak to retirement disability, but for disability, just standard disability, you've got to have 20 credits in the last 40 quarters, 5 out of 10 years, generally. If you're younger, a little bit less. So 20 quarters is normally what you would look to see. 24 seems like an odd number. I don't know that it applies here unless there is, unless you're talking about retirement, Social Security, or there's already, that's the only thing I can think you might be talking about. 24 credits. Again, it's, 5 out of 10 years, 4 credits a year times 5 is 20 credits. So it's not 24. Not sure where that comes from. And you're 54. So you would need, 20 credits, but not, my understanding is you would need 24. Not sure where that comes from. Okay, let's see if there's anything else here. Okay, Tasty Tracy. How to do dire requests get approved? Do dire requests, dire need is what you're talking about, get approved even if it's already been assigned to a DDS worker? Dire need is one of the methods to get your case put in the front of the line. Being 100% disabled vet would do it as well. There's certain other conditions. I think that anytime a dire need request is received, it'll be expedited to the person who needs to work on it. They may be really busy. Expedited might mean a week or 2 weeks or something like that, but it's probably faster than doing nothing. But they get approved if the medical is strong. And dire need suggests you've got an emergency, you need a decision, doesn't mean you need an approval. So if you're going to do a dire need, maybe look at doing a pre-hearing brief that really lays out your argument. Papa's Place. How much weight does severe vertigo carry? I've had pretty good luck with vertigo cases because when you're talking about vestibular dysfunction, your head spins, very hard to focus and concentrate. If vertigo is occasional, once every 2 or 3 weeks, less of a case. But if it is a daily thing or, every other day, that's going to be pretty work preclusive. So, there are some nystagmus, other types of tests that can be done visually to see how bad your, for lack of a better term, your eyes dancing about, your tremors, eye tremors are going on. But I think that they can be submitted at any point, and if it gets pulled for dire need, you'll get a decision faster. Cindy says, thanks for the info. You're welcome, Cindy. Okay. Proper Dame. Case has been at federal district court since April. What's your opinion of the time frame? Thanks for all I do. Okay. I would first tell you to make sure that you've not gotten a decision. They will send out things by mail, sometimes email, but it's certainly worth checking with your attorney or even calling the clerk of court to confirm the case has not been resolved yet. Because, let's say it got resolved 3 months ago, you were denied, didn't know you could appeal. What you can do in that situation is do special cause to get an appeal filed. It's discretionary, but if you didn't get the mail and it was lost in the mail, then potentially it could be viable. But as far as being since last April, I would say, that it's been at the court since April. You're probably getting close to a decision. That's typical time frame for district court. Thank you, Karen, very much. I appreciate the super sticker for $20. More importantly, my son appreciates it because those little tips go to the lunch fund for Jake Ginsberg, and Jake Ginsberg likes to eat like his dad. So we go out and we have a nice lunch and we talk about all my nice live stream visitors. But thank you, Karen. Appreciate it. You got it, Kenneth. I appreciate you. Karen, I do this because honestly, it's fun. I have a good time with it. It's just another way for me to talk to people, get questions answered. I'm a big believer in good karma. You send good stuff out in the world and it comes back. It also gives me content. Haven't done much with it, but that's something that I'm working on. Take the content from the live streams and make videos for YouTube and Facebook and all that. So that's something else. I have picked up cases out of it. It's also been a really good way for me to, meet other attorneys or to interact with other attorneys, get them on as guests. And I learn from them. So it benefits everybody. And I just think it's one of these things where Social Security is such a black box for so many people that, if I have the knowledge to make it a little more open, then I'm going to do that. But I appreciate the kind words. No, Christina, that's fine. It doesn't really bother me. I'm just saying, but if someone was to look me up as BURG, they wouldn't find me. They would find, BERG. Although it's interesting, I looked up my grandfather, who I never met. He died, I was about a month old. But when he came to this country, the manifest of the ship, he spelled it BURG. And somehow at Ellis Island, it got changed to BERG. There's really no difference in terms of the pronunciation, but there are people who are BURG, BERG, and we're probably all at some point related. Ginsberg, I looked it up one time, and the original name was Königsberg, which, by the way, Woody Allen's real name is Alan Königsberg. I don't know if I'm related to Woody Allen, probably not, but Königsberg somehow became Ginsberg. I don't know. It's an interesting question. But there have been other Ginsbergs out there. There's actually an attorney named Ginsberg. I forget his first name, in Florida. And the other day I get a check for like $6,000, a cashier's check made payable to, I'm not sure, Michael Ginsberg or whatever his name was. And so the person who sent it, their name was on the envelope. So I did a reverse lookup and I called this woman. I said, look, I just got this check. You're not one of my clients. what do you want me to do? And she was just, apparently she just did a quick search and found my address and sent it to me. So I sent it back to her. I'm like, it's not my money. I'm not going to take it, obviously. But and then the attorney, I think it might've been Allen Ginsberg. It was Allen Ginsberg, which is interesting because there was a famous poet named Allen Ginsberg. Again, I'm getting a little far afield here, but Allen Ginsberg called me. I missed his call. I was already gone for the day. And he's like, well, send the check to me, but I'd already sent it back to the client, which you got to do anyway. I don't feel comfortable sending money from, somebody sent me an error to a third party. I just sent it back to her. But he's a Social Security attorney. I don't know anything about him, but it's just kind of interesting that there's another Ginsberg in this. And I'll give you one more funny story. I don't know why. But I'm, I'll tell you, just because it's on my mind. When I went to school many, many moons ago, I went to a school called Tulane University in New Orleans. And Tulane, the mascot for the Tulane football team is the Green Wave, which is probably one of the more stupid nicknames for a team. It's not the Eagles or the Giants or the Predators. It's the Green Wave. And you got this wave, Green Wave, I guess because in Louisiana, there's the lake and all that stuff. Who knows? But anyway, my son went to Tulane for a year. He ended up transferring to Emory, but he went there for a year. So we went down there, my wife and I, for Parents' Weekend, and it was a homecoming weekend. So we go to the game, and the Tulane Green Wave plays in the Superdome. I think they now have their own stadium. At the time, they played in the Superdome. So I walked into the Superdome and walked into our seats, and I hear over the loudspeaker, now entering the game for Tulane, Jonathan Ginsberg. I'm like, what in the world is that? Well, it turns out that the kicker for Tulane that year was a guy named Jonathan Ginsberg. So never thought I would hear my name over the loudspeaker at the Superdome, but lo and behold, I did. And he spells it Burgh, like Pittsburgh. And he's now like works for a brokerage house investment advisor. He was a kicker, probably pretty decent kicker. But that night we went out to dinner, and it turns out he and his family were there, and we got a chance to meet him. And we were just kind of laughing how, Jonathan Ginsberg, was announced at the Superdome and is in the record books at Tulane. Not me, obviously, but another Jonathan Ginsberg. So, you never know. It's a kind of unusual name, but there you go. All right. So nobody probably cares at all about that, but it's my live stream, so I'm telling you. So anyway, all right. Let's keep going here. Jeff Brown from Facebook, does SSDI recognize findings from a place like QC Kinetics? What is QC Kinetics? Let's see what QC Kinetics. Regenerative orthopedics. It looks like it's probably a non-surgical treatment. I would think so. I mean, if it's under the auspices of a chronic regenerative medicine for chronic neck and back pain, I know that platelet-rich plasma, PRP therapy, is well recognized. So, yeah, I think that's fine, especially if there's an orthopedist or medical doctor kind of behind it. It is a form of conservative, non-operative therapy that, is better than surgery if it works. So yeah, I think an opinion of an orthopedist who is doing non-surgical treatments like, PRP injections or QC kinetics, I think that would be just fine. And I would honestly, if I needed back surgery or knee surgery or replacement or something like that, I would try anything before surgery, because if you can, even if you buy it yourself a year or two, surgery is always risky, and you come out of the surgery, it could be worse than you went in. So yeah, I think those non-surgical things would be good or fine. Christy, I thought that was odd too. Okay. About the credits, we're talking about the 24 credits. Yeah, that is strange. All right. Melanie Frost. The federal judge considered treatments and evidence past DLI, date less insured, remanded. The ALJ hearing letter says he's got to determine whether or not you're disabled before your date less insured. Who's correct? It's not about being correct. So what Melanie is talking about here is she went to a hearing, was denied, and then there was evidence in the file after the date last insured. In other words, she stopped working, her credits ran out. Let's pick a date, April of 2024. And then in June, July, August, or whatever, she had treatment, whether it's surgery or procedures or something like that. And the judge probably said in the decision, I'm not going to consider that because it's after the DLI. And the district court said, well, wait a minute. Even though it's after the DLI, it's reasonable to assume that if you had surgery 2 months after your DLI, that problem didn't arise 2 months after your DLI. It probably arose well before then. And so, judge, when you consider this case, even though the surgery, the treatment was, after the DLI, the evidence is after that, it's reasonable to assume that the problem existed before that. And I want you to, district court said to the judge, you need to consider these things that were subsequently treated after the DLI, but existed beforehand. You cannot ignore them. That's the basis of the remand. So in that sense, the district court is telling the judge, you've got to consider this evidence, even though it, arose after the DLI, it refers back to before the DLI. And then you think about it, it makes perfect sense. I mean, I've had cases where an MRI was in January of, let's say, 2024. My client's DLI was December of 23. Unless there is suggestion that there's an accident in January of 24, it's really, for all intents and purposes, the MRI would have shown the same thing 3 weeks earlier. So, I think you can assume that it was there. Now, if the MRI was a year after your date last insured, probably not. But a month or two, probably so. So I think that's what the district court is doing. This is kind of the same thing. Something that you may or may not be aware of is, when we deal with the grid rules, we have to deal with people's ages. And so, at 55, the certain grid rules apply. At 50, certain grid rules apply. There is a regulation that says if you are 54 years and 7 months, 8 months, 9 months, Social Security should consider you at the next higher age category, because in reality, the difference between 54 years and 8 months is essentially the same as 55. So they give you the benefit of the doubt. I think that's sort of the same concept here is, you can't raise form over substance and say, well, hey, because it was done after the DLI, it didn't exist before. That's ridiculous. That is ridiculous. Okay. Dasboff, 59 years old, physical job, severe degenerative disc disease in the neck, 11th grade education. What are your thoughts? 2 months, stop working. I think that, the grid rule almost certainly applies here. Look at grid rule 2020.06, or maybe the grid rule, if your past work was unskilled, it'd be a different grid rule. But basically at age 55, 11th grade education, assuming your past work is either unskilled or low and semi-skilled, even if you could do light work, you would be considered disabled. And light work is standing and walking 6 hours out of an 8-hour day, lifting 10 pounds frequently, 20 pounds on occasion. So even if you could do that, which is a fairly robust type of work, you are still disabled, because they realize that even people who could do light work, if you're 59 or 55, 55 plus, it's pretty likely there's not a lot of jobs out there for you with a bad neck, 11th grade education, and probably no real transferable skills. That sounds like a pretty good case. I mean, a lot of my clients are 55 plus because it gives me that, grid rule argument. So yeah, I would look that. I think that sounds like a pretty good case. If you have an MRI, especially, that shows that the degenerative disc disease is impacting the spinal cord, there's nerve root compression, there's spinal cord compression, and it shows something irregular there, really severe degenerative disc disease. That sounds like a winner to me. Okay. Tasty Tracy says, thank you very much. Tasty, my pleasure. St. Louis. Some time ago, I mentioned the name of a psychologist who provides independent psychological exams. Can you remind me of their name? St. Louis, do you know where that was? Because, I mean, there are plenty of doctors who do consultative work for Social Security. Why don't you email me and let me know where you are, and let me see if I can find somebody for you. There are doctors who do telehealth visits. There was one guy in Hawaii, of all places, who did a number of reviews for clients of mine. Not sure if he is still around. Let's see if I can find his name. I don't know. I'm not seeing anything here, but I'm not seeing anything. But yeah, why don't you email me and let me see if I can find somebody for you. Just, if I can. And again, you depend. Let me know where you are. I'll see what I can do. What I would look for is that I had cases in just about every state, and a lot of times there's a psychological consultative evaluation. Many of those doctors are pretty reasonable, and that might be a good place to start. They understand a little bit about Social Security, might be a good place to start, so we can try to find somebody. Papa's Place. Thank you for your hard work, even when I'm tired. Yeah, thank you very much. Yeah, I had I played 3 sets today. With a couple of people. One of the guys I played with, who's actually a medical doctor, who's really good. And, what I find is when I play tennis, I'm okay. I mean, I have a pretty good serve and I can hit the ball. But when you play better players, you have to hit the ball harder to get it past them. And the harder you hit, the less accurate you are. So I was kind of having trouble finding that balance where I would hit the ball hard, but it wouldn't necessarily go in. But if I didn't hit it hard, I was getting picked off. So, it was a bit of a challenge, but you get better playing better players. And so what my challenge is as a tennis player is, I play the same people a lot and I get used to their, I know how to beat them because I'm used to playing them. They know my weaknesses and strength. But you want to play people who are better. And that's what I did today. And I got my behind kicked a little bit. So, but that's fine. That's fine. I had a few good plays, but like anything else, you got to challenge yourself. So that's the way I roll. And tennis is nice because you can find people, no matter how old you are, whatever skill level, you can find people that you can play with. So I've sometimes played with my son and son-in-law who are in their 30s, and they're obviously a lot faster. Sometimes I can win some games or points because there's certain things I can do because I know mentally what I'm doing. I just can't always do it physically. But yeah, it's still fun. Still fun. One thing I played basketball for like 30 something years, really from the time I came out of law school till COVID. And then, after COVID basketball, people weren't playing because you're close and the leagues were closed. So I started playing tennis and I really enjoy it a lot more. It's a lot less demanding on the body and just as social. So it's fun. So I know a lot of people play pickleball, but I've played it, but I prefer tennis, a lot more running around. Okay. Jason Merck. I was approved in October, have not got my back pay. Social Security has already paid my lawyer. Is it normal? No, it is not normal. We've got this problem with several of our clients. I don't know what what we're doing is we're telling them to contact their U.S. senator to find out what's going on. I don't know. I was just doing a report the other day. I've got about 7 or 8 cases where I haven't gotten paid. So, things get held up, but sometimes you have to reach out to your senator to find out. I can't give you an answer because I don't know. It just depends on, why. I can't tell you. Do I play professional? Yeah, I do. I saw the final between Alcaraz and Sinner at the U.S. Open. That's a different game. I mean, these guys are incredible. I don't know if you've ever seen doubles tennis. It's a whole different game too. They're right at the net, very quick. A lot. I mean, it's a really different game, more so even than singles than what I play. But you really appreciate how good these players are. I've seen college players. Like there's a local college not too far from me, and I've gone to watch them play, and they're at a different level. And we're talking not even. I mean, this is like, a junior college. These are not Division I players. These are, junior college players, but they're 18, 19, 20, and they're killing the ball. And it's, I don't think I was ever that good. I wish I was, but you watch it, it's amazing, to appreciate how good they are, how hard they hit it, how fast the ball goes, and the reaction. Look, if you ever seen table tennis, if you ever want to see something crazy, go onto YouTube and type in, professional table tennis or, table tennis competitive matches. And it's amazing. I mean, I don't know how they do it. I really don't. But, again, tennis at my level is, I don't know what it looks like, to somebody else, but, we're hitting the ball back and forth, but it's fun. It's really, I'm not, maybe I'll be in the 90s, when I turn 90 years old, I'll be at the USTA 90s. Y'all can see me on YouTube. If you ever watch that, you go to YouTube and type in USTA, which is Tennis Association 90 plus, and you get these old guys running around hitting the ball, and they hit the ball. That's about as close as I'm ever going to come to any sort of a national tennis recognition, the USTA 90s or 80s. So maybe I'll get there at some point. But it's fun. Tennis is fun to watch. It's very athletic. It's a great sport because it's social. People generally are pretty nice. Yeah, not all, but most of them are pretty nice. And like I said, you can find people like with pickleball at any level. So, and it keeps you mobile. I think you got to keep moving as you get older. And I know a lot of people in disability, they can't do physical things, which is unfortunate. But anything you can do, whether it's swimming or walking, you always feel better when you're moving around. Okay. Maurice Mabry. The claimant has at least a high education. What does a statement mean? I think high school is what you're saying. Social Security, when they look at educational level, they break it down to, unable to communicate, in English, or, illiterate. And then they have, high school education, and then they have more than high school education, which would comprise things like college. So essentially what they're saying is that a high school education, they're going to assume, for the most part, you're going to be limited to unskilled or low-end semi-skilled jobs. They're not going to expect a high school graduate to do certain types of jobs that would only be open to a college graduate. Now, I will tell you that more and more, jobs out there are a function of, what you can do. But in terms of, qualifying for a job, if you're going off the street, you're not going to, you're a high school graduate or less than a high school graduate, you're not going to get a job as a radiographic tech. You have to have special training for stuff like that. So it just means if you have at least a high school education or a GED, that, is a basic level of education that would educationally qualify you for unskilled work, low-end semi-skilled work, and possibly higher-end semi-skilled or skilled work, depending on experience, as opposed to a person who is less than a high school education. There's less jobs available to that person, especially skilled jobs. So that's just how they break it down. Okay. How often a blue book? Good question, Christy. I'd say every 2 or 3 years we see a change. There's something I saw not too long ago. They're changing. I think it's the cardiac listing. They make sometimes minor changes, sometimes significant. The orthopedic one, the musculoskeletal, was fairly dramatically overhauled several years ago. It generally does not benefit you when they update it. They typically make the listings more difficult to meet. They eliminate some listings. Like a number of years ago, there was a listing for obesity. And, if you are of a certain height and a certain weight, you could automatically be found disabled. They got rid of that. The musculoskeletal listing basically they made it where if you can't meet the listing unless you're really unable to walk or use your limbs. It was not that restrictive before. So it's usually not a good thing when they update the listing, but they just do it to make it more difficult. And that's what they're doing. Give Grant, thank you. I try. I mean, I've done this for a long time and I've just called it the way I see it, but I appreciate that. Cynthia, how are you doing? Cynthia, tried for several days to get the office, came on the line. However, I'll keep trying. Yeah, it's real frustrating. I mean, I wonder when you call, I know that sometimes people call and they'll say, leave a message or give a callback number and they'll call you back. They're just understaffed. I mean, they really don't have enough people and it's really frustrating. Really frustrating, I know. RD, hello, RD from California. Have that same energy. Apply for disability. Suffer from ankylosing spondylitis, fibromyalgia, and major depression. My bones have begun to fuse. I am on Remicade, which is a pretty heavy-duty medication. Fusion treatment that makes me sick. What odds will get approved and out of work since 2020? How old are you is really a question I'm going to ask. And by the way, I was on an ankylosing spondylitis podcast a number of years ago. And that is, if you don't know what that is an autoimmune condition where your bones kind of fuse together. Not because they're supposed to, but they just do. And it can sometimes lead people in a lot of pain, physically limited. It's not necessarily, it's rarely a good thing. And Remicade is a, really, I think it's a chemotherapy agent. I know it's used for rheumatoid arthritis, inflammatory arthritis. It's a biologic anti-inflammatory, but it's got severe side effects. And the other thing about Remicade and a lot of these other biologics is biologic means a type of medication. They work for a while, but then they stop working and you move you to something else. And then you get side effects and so forth. So anytime somebody's on something like Remicade for ankylosing spondylitis, you've got some fusion going on. That's pretty severe. I still come back to how old are you? If you are 35, harder to win than if you're 50 or 55. So, but overall, that diagnosis and that medicine say significant problem. Is it enough to get you past the hurdle? I think that if you're over 50, much more so than if you're under 50. Okay, P. Brown, 59-year-old with moderate serolitis. I'm not sure what let me look that up and see if maybe you meant something else. Sarolitis. Sacroiliitis, maybe what you mean is an inflammation of the sacroiliac SI joint. I think that's what you meant. L5 and S1 degeneration, brain fog, and migraines due to long haul Lyme, severe fatigue, David 59 makes life a lot easier, no question about it. What does the MRI say? That would also say you've got moderate inflammation of the SI joint. That's going to make standing and walking difficult. L5, S1, how bad is it? What does the MRI say? Migraines due to long haul Lyme, that's a whole different issue. Lyme disease, causes a lot of significant symptoms, severe fatigue. Your symptoms are disabling, no question about it. Can you prove that there's a medical evidence support all that? That's the question. My gut tells me you got a pretty good case, but the medical record will tell the tale, and having a Lyme specialist say, yes, you've got Lyme, symptomatic, and these are the symptoms, will go a long way. But I think given your age and the nature of all this, I think you're probably in pretty good shape. Okay, the next is Angie Vasquez. Great question, Angie. What should be considered when deciding to appeal? Partially favorable, applied at age 52, judge changed to 55, back pain, diabetes, loss of vision. And I have this happen a lot. Social Security is doing this more and more at the administrative, the initial and recon level. Well, they will approve somebody, but they'll change the onset date, let's say from 52 to 55. And so what I look at is, number one, how much money is involved. Is it $3,000 or $4,000? Is it $30,000 or $40,000? If it's $30,000 or $40,000, you got to really look at it. If it's $3,000, $1,500, no, I wouldn't do it for that. Second thing I look at is the evidence. Is the evidence clear that you were disabled, at 51 or 52, or is it more of a 55? The grid rule applies. I've taken 3 or 4 of these to hearings in the last couple of years. So far, I'm 100%. We've won them all, where I'm able to argue that, in fact, the judge says, if you considered amending the onset to age 55, and I said, well, Judge, we appealed that. They were going to do that, but I appealed it. If the evidence is really clear that you would win at 55, there's not a ton of risk. The real risk is you could draw a really bad judge. And I remember I had this conversation with one of my clients. I said, okay, you were approved. You want to appeal an approval. You're approved of your 55th birthday. Evidence is pretty compelling here that at a minimum, you should be approved at age 55. And the judge, you're in the Mobile, I think it was Mobile, Alabama hearing office. There are 9 judges there. All of them are reasonable except one who's got a very low approval rate. So do you want to roll the dice? And if we appeal it and we get this low approval judge, all bets are off. We can't undo it. We get any other judge, we got a reasonable shot at it. But even the low approval judges, are going to approve people over 55 with something significant. Look, I had, Rodney, who's on here sometimes, had a judge who is one of the most difficult judges in the Atlanta area, rarely approves any cases. I had a hearing with him the other week. He approved it on the record. Client was over 55, or actually the client was 54 and a half at onset, or 54 and 7 months. He moved it to 55 and he approved it on the record. I about fell out of my chair. So even the low approval judges will approve good cases at 55. So, Angie, you probably don't have a lot of risk, but, for some people, any risk is too much risk. I mentioned this the other day. I had a client that by changing the onset date, it cut him out of over $100,000. Called him up. You want to appeal it? No. And he got no back benefits at all. I said, are you sure? I think the risk is worth it for $100,000. Nope, don't want to do it. Okay, can't force you. For some people, they'd rather have ongoing benefits and forego $100,000 in back benefits. I wouldn't, but that's me. Okay, Jeff gives me a whole list of numbers. Honestly, Jeff, I'm not going to do the calculations. I mean, it looks like you've probably got, for all these years, you got a lot of years with enough credits. Look at your My Social Security statement or call Social Security and say, what is my date last insured? I can do the manual calculation, and you can look up, if you want, the dollar figure per credit hour for 2024, 23, 22, and so forth. And you can create the table and see how many credits you got in 22, how many you get in 23 and 21 and so forth. Obviously, none in 19, 18. So the zeros are going to hurt you, but you've only got, looks like 4 or 5 zero. It's just going to depend. I mean, it looks like you've worked, somewhat consistently since 2020, maybe, or 2021, it looks like. So yeah, you may need to do that calculation or ask them, are you insured, or how many more credits you need to be fully insured? I can't really, I'm not going to do it manually here, but it's doable to figure that out. Heather Energy has had unnecessary back surgery. Yeah, you have back surgery. It's either not necessary or you end up no better off than you were, and very frustrating. Sharon, any more continuing reviews? Probably not at 63, Sharon. I don't think so. I think it's just unlikely, very unlikely. Sharon's one of my clients. I have the same issue, diagnosis of AS, fibro, and major depression, qualify for disability, but I work since 2020. I have other work credits. I mean, fibromyalgia is a tough one because it's sort of this very objective kind of thing. I think the ankylosing spondylitis is stronger. I think did you notice that you had Lyme disease, depression? Look, anytime you have things that are kind of invisible illnesses, it can be a bit of a challenge. It's just a matter of what the evidence says. But in theory, yes, those things would qualify you. It's just a matter of what the evidence says and what the judge believes. Walter Knott. Walter is another Social Security attorney. Says he recommends a seated MRI for lumbar and back radiculopathy and impinged nerves, rather less powerful. What are your views? Don't really have an opinion. I think that open MRIs in general are going to be probably a little less accurate than the traditional MRIs. I would leave it up to the radiologist. At the end of the day, you need to get, if you need to get an MRI, you need to get an MRI. Some people cannot tolerate the closed MRIs, and they wanted a seater, they wanted a open MRI. I think ask the doctor what gives you the best results. That's really more of a medical decision. But I would agree with Walter that any MRI is better than no MRI. So if you can't tolerate a traditional MRI, a seated or open MRI would probably be better. But I would leave that up to a doctor. Okay, if you have advanced degrees, medical diagnosis of anemia, migraines, carpal tunnel, back knee, anxiety, depression, and age 55 unable to work, will the grid help? Yes, I think that if you're 55 and older, or 50 to 55, realize the grids only apply when you have physical limitations. They're not going to apply to migraines. They're not going to apply to anemia. It's only going to apply to the physical stuff, the back, the knee, the carpal tunnel. So ideally, you need a treating doctor to basically say you're limited to sedentary or light work, and these other things would erode depression, anxiety, and anemia, migraines would erode any transferability of skills. Okay. Stacy, 62-year-old female aircraft structure mechanic. Good for you, Stacy. I have a high school diploma and a recent training where my job be considered skilled. I think so. Carpal tunnel in both hands, herniated disc. I think that structural mechanics is probably a skilled occupation. However, it is probably the skills only really probably apply to, aircraft mechanics. There's probably not a transferable skills out of that. And then you have the POMS regulation, which basically says that when doing a transferability skills analysis, that they can't assume you could transfer out of your industry. So unless there are lighter jobs that a person with your knowledge and skills could do, those skills, while transferable in theory, as a practical matter, don't really transfer. So it gives you a way to get out of these skilled, essentially you've got no transferable skills, 62, the grids apply, so it works in your favor. So that's what I would tell you about that. Jimmy London, heart surgery. I had 2 cervical surgeries in my neck and a hip replacement. That's 4 years of hearing on 29th. My doctor says I'm disabled. I can't get my benefits. Again, I'm not going to make it. I don't offer opinions without looking at medical, but 2 cervical surgeries, which suggest maybe this failed neck syndrome, hip replacement, in all the last 4 years. If I'm your doctor, I think that sounds pretty compelling. It depends on how the surgery is worked out and what the doctors have to say. Christy says, my favorite player was at college level was John Isner. Yeah, Isner was played the pro. He was a Georgia Bulldog. That is correct. He played, he was a serviceable pro, played for a number of years. He's retired. But yeah, he made the circuit. There's actually a guy that I'm on a team, an Alta team, which is like a local lawn tennis association, like USTA. And so my team, we have a practice every week, and one of the coaches at the practice is a guy who was like 300 in the world. He's probably in his 40s at this point. I mean, he's beyond unbelievable. I mean, he's, like I said, he was like 300 in the world at one point. I'd be lucky to get a point or 2 off of him in a set. Again, the level of skill is unbelievable. I remember when I was young, and this is going back to high school, I went to a tennis camp called the Fairfield Tennis Academy I think it was in North Carolina in high school. And a couple of the coaches were college players. And one guy had been on the Pakistani Davis Cup team. I'll never forget this. Adnan Khan. Adnan would this is when we had cans. He would put a can of tennis balls or empty can on the corner, run on the service in the middle and on the other corner. He would hit the cans consistently with his serve. You couldn't even see the ball was going so fast. Again, just different level stuff. And I can't imagine what, guys like Alcaraz or Djokovic or Sinner, what that must be like. There was a YouTube video I was watching where Ben Shelton, who was actually born in Atlanta, Ben Shelton's a professional player. He's got a really hard serve, one of the hardest serves on the tour, and he's getting better. He's really improving. He's made semifinals, a number of things. And so this guy, I don't know, it was in some sort of a promo thing, and he was, hitting with Ben Shelton, and he said, okay, I want you to serve me the ball starting at about 30% and kind of moving on up. He could hit it at 30, maybe even 50%. Beyond that, he couldn't even catch up with the ball. It was just coming too fast. And you get a pro serving, and I was watching, even the women were serving at 110, 120 miles an hour. I mean, you'd have no idea how fast that is. It's just, your reactions have to be just late. You have to be able to, laser quick. And I can return a hard serve, but I mean, I'm probably returning serves that are 80 miles an hour, maybe 70, 80. I couldn't imagine returning 110, but yeah, Isner was pretty good. Had a good serve. Keisha May got an overpayment last year in February, paid half for 6 months. SSA back last month at 96 lakh letters, that overpayment. I know they've gone back and forth on it about what they're going to take. There is a form you can fill out to ask them to minimize what they take out of your check. So, you should try to negotiate with them about taking as little as possible. KU Thunder. Any future guests? Yes, I have Andrew Sindler, who's another attorney. Andrew does a lot of seminars, teaches a lot of seminars. He's got a YouTube channel. His videos tend to be 30, 40 minutes, but he's a really sharp guy. He answers a lot of questions on the NOSCR listserv. I saw him speak at the NOSCR conference last year, so I'm going to have him come on in a couple of weeks. I've got an adjudicator coming on, a current adjudicator. We're still negotiating about how this person will come on. They don't want to come on with their name or their image, so it'll be probably audio only, and a fake name, because this person's still working for Social Security. And, this person is going to talk about what it takes to win cases. I've got somebody coming up later in October, a woman, Tricia Cardillo, and Tricia used to be a non-attorney rep, which meant she tried cases like I do, but she was not an attorney. And she went to medical school. She stopped doing her thing, as a non-attorney rep, went to medical school and became a psychiatrist, an MD. I saw this on LinkedIn, like, wow, that's pretty impressive to do this in your 30s or 40s. I'm not sure how old she is. And so I emailed her the other day and I said, Trish, I saw you went to medical school. That's amazing. And she put on her LinkedIn, why she did this is because she felt like that, as a claims rep, there's only so much she could do. And she saw a lot of people, especially with psychiatric issues, that were just really not getting appropriate. They weren't getting on benefits. They were having trouble getting treatment. So she's like, I think I can be more help as a psychiatrist. So I'm going to have her come on. By the way, St. Louis, I'll have to see if Trish does a remote work. That may be somebody. Again, email me. And I know a couple of people who do remote work, and that may be somebody to talk to as well. But she's going to come on. We're going to talk about her experience as a hearing rep, and also, what she has seen now that she's a psychiatrist, what her opinion about what it takes to be disabled. So those are the people got coming up. I'm sure Stefan will be on again. I'm going to try to get Spencer Bishens back. That was a really good one. Spencer used to work for Social Security, and he was very enthusiastic talking about that, gave away a couple of copies of his books. I'm trying to get a couple other attorney friends of mine on. So, we'll keep doing that. It's actually nice. Like when Steph and I did this last week, a lot of give and take. It's a very nice, I enjoy doing it that way. And I think we got a lot of visitors. People tend to like it. So we'll do that. Keisha was asking about the SSI. Yeah, because you didn't pay it in full. At one point they were going to limit what they could take from you. Now they got rid of the limit. They're going to take more. So I think you need to negotiate that. Okay. Unnecessary back surgery. I hear a lot of people with that. And it's very frustrating. RIP Detina. RIP, been on before. What happens if you have an aneurysm or sleep apnea diagnosis at medical history? When you apply for disability to other impairments, the ALJ still have to consider the effects of your aneurysm and sleep apnea in your RFC. If it's developed, and realize that step 2 of the sequential evaluation process says or asks, is the impairment severe? And so you may have a diagnosis, but unless there's medical treatment of it, a judge can decide it's not severe. I have a case coming up next week where my client had a stent put in the heart. I had cardiovascular disease, but it's going back 15 plus years. The initial adjudicator found that cardiac problems were a severe impairment. The recon adjudicator said they're not. The question is, are there any functional limitations for in this guy's case, the cardiac issues? I think here, you had an aneurysm and sleep apnea. What does that mean? Is there any kind of treatment? Can a judge decide it's severe? If you had an aneurysm but didn't, and it was repaired 20 years ago, you have sleep apnea, but it's no longer symptomatic, or it's not being treated with a CPAP, anything like that, a judge could decide it's not severe. Now, judges also have, as representatives of the Social Security Administration, the obligation to develop your record. That's why they send you out to consultative evaluations. So I think if you put in your application, I've got these conditions, but I can't afford to go to the doctor, they have an obligation to send you out at least for consultative to try to direct it. But again, the real question here is, what does this mean functionally? Aneurysm, for example, if it's not been clipped and not been treated, that can impact you psychologically because you're wondering, when's the other shoe going to drop? Maybe you're told you have to limit your exertion, climbing stairs, things like that. That could limit your job performance or job possibilities. The sleep apnea, you're not going to win a case of sleep apnea, but again, non-restorative sleep may get rid of certain skills or limit you to unskilled work. It depends on sleep apnea. Depends on how severe it is, and whether the treatment's effective. So, could be severe, possibly not. All right, Jeff, and again, you're asking me about your insured status. It definitely helps to be 53.5, but you got to find out if you're insured. Can you apply for retirement benefit? Yes, you can. At 62, you absolutely can. Which the Stockton, California was like Mobile. Some offices are more reasonable than others. I've had cases in Stockton. I don't remember it being particularly unreasonable. There was something I found the other day. Let me see if I can share this, if it in fact it is what I think it is. Give me a second. Okay, Stockton. What I'm looking at is okay. So there is a resource I found here, and let me put this in the chat notes, that you can put in the name of the judge or the hearing office, and it will give you data. Like Stockton, all the judges, the approval level is 37.6 or 44% win versus 55% loss. That's lower than average. And then it talks about the different judges. Here's one at 41%, 46%. There's one at 29%. Here's one at 63%. Here's one at 53%. So you're in Stockton. If you get judge basically 30%, much more of an uphill battle. You get judge 63.5%, going to be easier. But look at that tool, and that may give you some ideas about, what the judges are and you're in that particular office. And this is all public record. This is just some law firm that put this on the internet, which I use. How long are they taking with decisions? 2 to 6 weeks on average. Just depends. Walter says, when people talk about the type of MRI, I'll take Walter's word for it. I don't have an opinion. I've not heard that, but could be. I think, again, a radiologist would be a better person to ask than Walter or me, quite frankly. Is cervical spinal stenosis or stenosis itself a listed disability in the Blue Book? I think it's referenced in the Blue Book. Let's see. Let us take a look at musculoskeletal listing, and I'm just going to do a quick search for stenosis. Yes, 1.16 talks about spinal stenosis. And then, I think it is referenced in the Blue Book at 1.16. It's got to be severe, but yes, it's in there. Timeframes on decisions. As I said, it can be as little as a couple of weeks. It can be as much as 3-4 months. Just depends on how busy the particular hearing office is, how busy the writers are. 45 is 7th grade education, currently on 10 milligrams. Remicade, hips been diffused, rheumatologist, today's medication progressed. Yeah, that sounds like a pretty good case. The 45 is going to make it a little more difficult, but everything else lines up. Less than 7th grade education. I assume past work is unskilled or low and semi-skilled. You're on Remicade, which makes you sick. Your hips are beginning to fuse. You've got a bunch of other things going on. Yeah, I think it's good. I mean, if you were 50, 55, better, but I think it's still winnable. Golfer Pro, hearing in the morning, wish you luck. Good luck. I have 2 hearings tomorrow, one at 8:30 in the morning and one at 3 o'clock in the afternoon out of California, which is 7 o'clock my time. So I've got it 8:30 in the morning at 7 o'clock. So I'm on a long day tomorrow. Doctors can't get my condition under control. They said I left it untreated for too long and diagnosed damage is untreatable. Yeah, again, that says that you are likely to be, you're 45, you got the ankylosing spondylitis. The doctor would complete a functional capacity form for you. That would be helpful. But yeah, you've got a lot of stuff going on here. The 45 is the only thing that would give me pause. But, people at 45 who get approved are going to be at a serious level of impairment like you. Cynthia says, good luck. Okay. You also enjoyed the long life shows. Yeah, Steph's been on a few times. And right, Adriana De La Torre is an appeals lawyer, and she's great as well, having her on. She's fun to have on as well. She has some insight as to what goes on in federal court. And it's always very interesting. The NOSCR conference is in San Diego. I think it starts tomorrow, maybe today or tomorrow. So a lot of people are attending that, some virtually, some live. I went to the one in Nashville. I was going to go to the one in San Diego, but it's a long way. And, family obligations, got a lot of stuff going on, a lot of hearings. So I just chose not to go this year, but I enjoy going to these. I've spoken at them before. It's always interesting to network and to pick up things. So yeah, I'll go, but yeah, I didn't go to the one this year. Good luck. Good vibes. Good vibes are always good. Thanks. Going to get a good night's sleep. Yes, you should. Press the like button, please. Thank you. All right. This is the link I was going to give you before. Walter has made statements about some who are on disability that are better so they can work as well. Look, anytime you can work, you should. What you don't want to do, in my opinion, is be in that situation where you are working enough to be over the SGA limit and therefore lose your benefits, but not working enough to make enough money to live independently. That's the balance you got to strike. And I think sometimes people work in good faith thinking they're helping themselves and they're making things worse because they're over SGA. Okay. Jamie, I'm 55, 2 neck surgeries, takes Oxy, never got better. And yeah, I think you got a good 55. Yeah, that sounds pretty good to me. Rip, you're welcome. Good luck, golfer. Yes. Christina, if you're trying to get a set, doesn't mean you're going to get a judge from your city. Usually, they are like I have a hearing. My client lives in Hawaii. I think it's on. I don't think it's one tomorrow. Maybe Friday, and the judge is in California. I've had cases with people live in Alaska. The judge is in Washington State, but I suspect with Bakersfield, you'll get a Bakersfield judge probably. I've had every once in a while, I got a client in Maryland who got a South Carolina, really bad South Carolina judge. But, most of the time they try to get people local. So, because you have a choice to ask for a local hearing. And obviously, they're not going to expect you in Bakersfield to travel to, Las Vegas or something. So, but usually you're going to get somebody fairly local for you. Yeah, if the doctor filled out a form, that's very helpful. I think RIP is correct, although not always. They will sometimes do it beyond that. That's correct. I started the live stream last May. I was at the NOSCR conference, and I just had never done it before. I was actually using this device, which I still have it sitting here. And I need to sell it because I'm using now StreamYard. But I got this really cool device, and looks like an iPad, but it's really used for people who are streaming live events. It's a streamer, and you can stream like football games or baseball games, and you can have like multiple stream destinations. The thing is StreamYard, which is what I use, is so easy that I don't need this other thing here. I just need to probably sell it. It was like $1,000. I need to sell it. I'm sure somebody could use it. Just got to get around to doing it. Miguel says, thank you. Thank you. You're welcome, Miguel. How are the judges in Arizona? Well, again, look at that link. Look at the city in Arizona or the hearing office in Arizona and see. I think you're going to have a variety, some that are more reasonable than others. My buddy, now I'm drawing a blank on his name, Desert Disability. Now I'm thinking, I don't know why I'm drawing a blank on his name. He's been on before. Oh no, this is embarrassing. But I remember he told me he had very strong opinions about Jeff Herman. And Jeff had some very strong opinions. He's in Scottsdale, Phoenix area, and he had some strong opinions about Arizona judges. Some of them he thought were really good. Some of them he thought were really difficult. So, but look up that tool. You're welcome. Maggie, 58, stenosis of cervical lumbar with 3 back fusions. Crohn's and colitis, arthritis and double knee, never graduated. Yeah, that's a good case. I can tell you. That's a good case, Maggie. I would take that case. Cynthia says, thank your team. You're welcome, Cynthia. Thank you. Right, that Rhea Walter spells his name H-N-O-T. How does LTD payments? It's not going to affect Social Security. What it does is that the long-term disability carrier is going to say, you've been approved for Social Security. You now need to pay us back your lump sum. So it's going to, you won't keep your lump sum from Social Security because they're going to say that the premiums they charged were reduced because of the lump sum, because of the Social Security benefits they paid you. But it won't affect Social Security. It affects long-term disability, and it reduces it. Go, Joe. You're welcome. Right. Let's see. Racing Crazy 8. I filed for SSDI in June for cardiac. I'm 60, heart failure, quad bypass. Sent forms 3369 DS, return them fast overnight. No, I think if you call them and say, I just got them, I need a week, 10 days, they'll give it to you. I mean, you don't need to get them back tomorrow. I think just give it a couple of days, but I'd let them know. If that happens, not at all. Yeah, thank you, Maggie. That would be great. Definitely fill out the form. I've got the link right here, and just let me know you're on the live stream, and I'll get right back to you. That's a good case. You are very welcome. Let's see where we're at comment-wise. Wow, that's all the comments right now. Let me just do this here. Banners, a couple of things I want to talk to you about. I have an Instagram channel I'm trying to build up. So please visit me on Instagram, Ginsberg Law Offices. And then let's see. If you want to leave me a review, that's where you do that, the Jonathan Review 5. Reviews are always really, really helpful because they really demonstrate, people, it helps my search engine positioning, and other people read them, and that helps me a good bit. Okay. All right. I do not see any more questions here. Anybody have any more questions? Please ask them. Otherwise, I'll end. Let's see if there's anybody has anything more. Not seeing it. Okay. We are now at almost 10:30. A little shorter than normal, but we had a smaller than normal crowd here. We're about an hour, 45 minutes. So I'll go ahead and end. But I appreciate everybody joining me tonight. And I hope you have a wonderful fall. We're getting close to the official start of fall. I know here in Atlanta, like today was just gorgeous. It was like 75 degrees, not a cloud in the sky. It was great. So hope where you're at, you're starting to see some nice weather. And we will see you all next week. And I'll put one thing I didn't do today was I didn't put this notice out as early as I normally do. I'll do a little better next week. Hope to see you all next week, and everybody have a great evening. Y'all take care now. Bye-bye.